Hello, my name is Ashleigh. Today I will be discussing the case of Reckitt and Coleman Limited against Borden and Corporation in 1990, Volume 1 of All England Law Reports number 873. I will be discussing the facts and the holdings of this case, as well as a brief look at its legal implications. This case is in relation to the tort of passing off. Passing off is an action for holders of an unregistered design to enforce their rights when their mark, design, or packaging has been copied. This case is the leading authority in relation to passing off, as it established the necessary three elements for a successful action. The facts of the case are Reckitt and Coleman, under the name Jif Lemon, sold lemon juice in a yellow plastic container shaped like a lemon. Borden, an American competitor who entered the UK market, was selling lemon juice called Real Lemon in a similar shaped lemon container. The only difference was a slightly larger bottle with a flatter side. Reckitt and Coleman went to the House of Lords to get a permanent injunction against Borden. Lord Oliver held that there are three elements to an action of passing off, and these are referred to as the classic trinity. The first element is the goods or services have acquired goodwill or reputation in the marketplace that distinguishes such goods and services from competitors. The second element is the defendant misrepresents his goods or services either intentionally or unintentionally so that the public may have the impression that the offered goods or services are those of the claimant. The third element is the claimant may suffer damages because of this misrepresentation. The most difficult element to establish is the first element, proving that the goods or services have acquired goodwill or reputation in the marketplace, which is distinguishable. In this case, it involves submitting a market survey as evidence as to distinguishable reputation. A defendant may also submit a market survey suggesting that they have the goodwill of the market as rebuttal. Reckitt and Coleman submitted that when a consumer saw a lemon-shaped bottle, they assumed it was their Jif Lemon product. There was clear evidence through this survey that Jif Lemon had acquired the goodwill of the market in the UK. This element does not need to be proven in the case of registered designs or trademarks. The second element was clearly met, that Real Lemon was misrepresenting their goods as Jif Lemon. This was seen due to the similarities in packaging that induced consumers into believing they were purchasing Jif Lemon. Although this was unintentional, the public, as seen in the market survey, were misled. The market survey also proved the third element, that the claimant may suffer damages, as it showed that consumers were purchasing Real Lemon believing that they were purchasing Jif Lemon. Lord Oliver phrased this element as, if the answer to that question is in the affirmative, it is, on the balance of probabilities, likely that, if the appellants are not restrained as they have been, a substantial number of members of the public will be misled into purchasing the defendant's lemon juice in the belief that it is respondent's Jif juice. The court found it was clear on these facts that Reckitt and Coleman may have suffered a loss due to Borden's misrepresentation. Reckitt and Coleman were successful and were granted a permanent injunction against Borden, thus developing the tort of passing off into its current standing in common law. This tort is important as sometimes, as in this case, the packaging or the marks of the design do not fall under registrable designs or trademarking. This allows for protection of business goodwill and reputation outside of the trademark or registrable designs. Thank you for listening to my presentation today on the case of Reckitt and Coleman against Borden.